Are we all ready to proceed?
Yes, we are, Mr. Chair, but if I can just remind anyone who is waiting for their application to be heard, if they can raise their virtual hand when the application is called, if they do want to speak to an application.
Okay, thanks. All right. Good afternoon and welcome to this online hearing of the Committee of Adjustment for the City of Ottawa. Committee of Adjustment is a quasi-judicial tribunal appointed by City Council to make decisions on certain types of applications under the Planning Act. My name is John Blatherwick and I will be chairing this hearing today. With me are my fellow panelists, Heather McLean, Stan Wilder, and Bonnie Oakes Charon. Please take note that this video conference is being live streamed on YouTube. The video will be archived along with today's agenda on the city's website. Before we begin, we have a few items to outline for your information. While the issues surrounding development of the city are broad, our mandate is quite limited. The committee cannot consider the following: aspects of the proposal that are not related to the required variances, noise, pollution, property maintenance, property values, prosecution for illegal construction, personal comments regarding neighbors, agents, or applicants, additional variances without proper public notice. If there is an identified need for an additional variance or variances, including an increase in the extent of relief required, a recirculation of the application is required. As part of the statutory public notification requirements, each applicant was required to post a sign on the property and file a statutory declaration confirming the sign posting. We will be administering the oath to every applicant and or agent for all of these applications today in order to make sure that the stat dec requirement is met. Regarding quorum, if this is lost during the hearing due to technical difficulties, the proceedings will be paused to allow time for the resolution of the issue. Failing the ability to reinstate quorum, hearing of the items remaining will resume at the outset of the next regularly scheduled meeting of the committee. In terms of the hearing process, listed on the agenda and appearing on the screen are the applications we will hear today. For the sake of efficiency, the committee may deal with agenda items in a different order. Note that the committee members have reviewed the application materials prior to this hearing and any written submissions received in support or in opposition. In addition, the committee will hear today oral submissions from any interested parties as part of our proceedings. The committee may ask for a brief presentation by the applicant, followed by questions from the members where clarification may be needed. The public submissions portion of the hearing will then begin, and any interested parties will be invited to make their submissions to the committee. Panel members may ask them to ask follow-up questions where added clarification may be required. When you are called upon to provide your comments, we will ask you to do the following. Start with stating your name and municipal address for the record. We may ask you to spell your name. Then begin your submission by addressing your comments to the panel member. Exceptions will be at the committee discretion. Parties have had an opportunity to address the panel, the public submission of the hearing closed. The committee will then make an oral decision to either grant or deny the application. The committee may also choose to reserve its decision. In such case, the panel will deliberate further on the evidence presented immediately following adjournment of the public hearing. In either case, the committee will send within 10 days of its decision and to all parties and those who have requested it, a written decision that sets out the reasons for the decision. All decisions of the committee are subject to a 20-day appeal period, during which the decision can be appealed to the local planning appeal tribunal for a fee. Before we begin, are there any declarations of interest regarding the panels today, 1, 2, or 3, for any of the members? No? Okay. We have no minutes to confirm. I do not believe, Madam Coordinator, that there are any adjournment requests. So with that, we will move to the applications. And the first application we will hear will be items 1 and 2, 656, 656B, Edison Avenue. I believe Miss Murray is the agent for this. Can you hear me, Miss Murray?
Yeah, I'm just waiting for the audio. Do you hear me?
Yes, I can.
Yeah, okay, great.
I have to administer the oath for this application. Do you
Yes,
solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
yes, I do.
Okay. All right. This application is a consent to subdivide the property into two separate parcels. One parcel will contain the existing two-story detached dwelling, and it is proposed to construct a two-story detached dwelling on the other parcel. The one-story addition located on the south side of the existing dwelling is to be demolished. Minor variances to permit or reduce lot width and lot area are proposed. It is also proposed to construct a two-story detached dwelling on the southerly parcel, which would be known as 656B Edison Avenue. So if you'd like to make a presentation on this application, but if you could please, Ms. Murray, staff have noted that the streetscape character analysis process has not been completed. Is there a reason?
Well, no, I don't have a specific reason. So sometimes it's done by the architect acting on behalf of the applicant. Sometimes it's done by myself as part of the minor variance or consent application. So in this case, we've been discussing the file with staff starting back, I think, in December, January. It didn't come up and we hadn't applied yet, just as a matter of
Our
course.
concern is that if there are any changes as a result of the SCA, you may be back before us with more variances.
Yeah, I did have a conversation with the staff planner, and after the question arose, I did review the streetscape as I had already done and looked at sort of the garage and the front doors. I don't believe there's any issue, but to actually file and get the approval of the application takes normally a few weeks. So the paperwork just hasn't been done.
We're just cautioning you that if it doesn't
Yes.
work out, we may see you again on this application. Anyway.
Yeah, well, we've got a front door facing the street, and we've got a single car garage, which is allowed under the streetscape. We have not done the paperwork with the city.
Okay. All right. If you'd like to proceed with your application, please.
Yep. So I did ask that the planning rationale be on the screen, but I'm also fine with the survey or the site plan there. That's perfect. So basically, it's a severance to sever part 2 and retain part 1. The applicant plans to retain the existing home. It had a one-story addition added at some point onto the home, and they'll basically just be removing that and replacing that with a new 2-story single-family detached home. The lot width sort of would have allowed us to meet the zoning if we put the property line closer to the existing dwelling, but in order to meet sort of setbacks required on part 1, we propose instead to request a small minor variance to both the frontage, the lot width to be 8.73 instead of 9.0, and the lot area to be 267.2 instead of 270. So these are truly very minor variances to allow for for the house to be retained first of all, and for a new house to be built on that frontage. So we've also identified, and we've gone through the full sort of review of official plan and zoning. And we've also provided in the planning rationale a number of examples of adjacent development that is consistent to this scale in lot width and lot area. I don't know if you want me specifically to go into any more detail, but I'm happy to answer any questions from the community.
Well, we'd like to see the elevations of the proposed addition.
So this is the front and the rear on the right. The existing house essentially stays as is with some, there's a removal of a back deck also, but this is the proposed elevation. So the applicant
How
has,
how
the
far
applicant
above,
lives,
pardon me?
sorry. I was
Go
just
ahead.
gonna say the applicant lives in the house currently, and has spoken, I think, in an informal way with the neighbors over the past few years about plans to develop the lot. They had looked at doing 2 long semis, but they decided that this was a more appropriate form of development for this lot.
Has the applicant talked to their neighbors about the balcony at the rear? And the possible impacts, noise, light?
Well, I believe they've shared the plans generally with some of the neighbors.
Some of the neighbors being, which neighbors? Side, behind?
Yeah, well, I honestly, I don't know. I mean, everybody was circulated on the application. But I believe they've certainly spoken to the neighbors on either side. I'm not sure if they've spoken to the neighbors in the back.
And the necessity for that balcony? Because you do have a fair amount of amenity open space and grade in the rear yard.
I mean, I guess it conforms with the zoning. We're not asking for any variances on the balcony. I understand your question. I think there certainly is a lot of rear balconies in the context of this neighborhood. I think front upstairs balconies are maybe less common, but rear balconies are, I would say, are fairly common.
And on the new house, the distance between the rear of the new dwelling and the neighbor on Melbourne would be approximately how far? In your
The
estimate?
setback,
No, from the back, from the rear of the house to the rear of the property on Melbourne. What's the any idea what that distance would be?
oh, it's 28.5 feet, 8.67 meters.
That's to your rear property line.
Oh, I don't know what their setback is on their side. No, I'm sorry. I'm just looking at GeoOttawa, or the map, which is on page 18 of my planning rush, or my planning letter.
Mhm.
Looks to be a fairly significant setback, or fairly standard setback on 655 Melbourne Avenue.
Right. If you could address the 4 tests very briefly on this application.
Yeah, so I'm just referencing my planning rationale. I realize it's not on the screen, but
We have a copy.
yeah, so I mean, do you want me to go through the detail, or just confirm that we've reviewed it? And do you want me to go
Well,
through
briefly
each of the 2?
give the rationale for the 4 tests, please, if you wouldn't mind.
Okay, I'll just flip through. So the 8.73 width, in reviewing the various sections of the official plan, we believe that the proposed lot severance is in conformity with the official plan, and the proposed minor variances are also consistent with the objectives of the official plan. So we've reviewed section 2.5. I'm just sorry, I'm flipping. 2.51, the urban design and compatibility. We've looked at the compatibility, and 4.11, urban design and compatibility. We feel that both those sections it conforms. Then the zoning bylaw, we've looked at the comparative lot analysis. It's generally in conformity with the zoning bylaw, with the exception of those minor variances. It is minor in nature, certainly in numbers, but also in impact. So there is the form of detached housing that we're proposing certainly fits within the context.
At the present time?
What's that?
I was just wondering, I mean, your signal was breaking up. I'm just wondering if everybody can hear you, everybody else can hear you. Yeah, okay. That's probably my internet connection. Please continue.
Okay, so just we've provided, and I'm happy to talk more to them, but we've provided several examples of both detached and semi-detached in the immediate area that are of a similar or smaller frontage and size. So it maintains the general intent and purpose of the zoning bylaw to provide detached housing. It's minor in nature. The impact of allowing for a detached home to be built on this street, I think, is entirely consistent with the type of redevelopment that has already happened in this immediate surrounding area. There's a number of examples of infill on Edison, and especially on the corner lots nearby.
Yeah.
And the variances are desirable for the appropriate development of the property.
Right. You're aware of the conditions that have been requested, building code services and the spatial separation analysis of the south elevation of the building?
Yeah, I did ask a question back to building services about that on Friday, and I didn't see a reply yet, but we are aware of those, yes.
Okay. And planning department, cash in lieu, independent services.
Yep.
Information on existing structure demolished and with a demolition permanent relocated and conforming to the zoning bylaw, grading and drainage plan, all the standard stuff. You're aware of
Yes.
all those, I take it.
Yes.
And you're aware of Hydro Ottawa's comments regarding their separation distance from.
Yes.
Okay. And a request, obviously, a demolition permit before building permit is issued. And your SCA, the streetscape character analysis is pending.
Yep.
So it'll either be completed by you or by the architect.
Yeah, and the applicant understands that they couldn't proceed to a building permit without
Okay.
that.
So that's pending to the department. Any of the members have any questions on this application? Doesn't believe they have any questions on the application. I think we're prepared to vote on the application. I think we've discussed that the application approval of the application should be tied to plans filed for this project.
Okay. What's the rationale for that, I guess, with lot width and lot area?
Ms. McLean? You're muted.
Sorry, I think the official plan drives the requirement for plans, and I think you noted in your cover letter the section about compatibility and that new development must fit in and coexist with existing development. So when we're creating an infill lot, we need to evaluate the development that goes on that lot in order to assure that it does fit in with the existing community character. So in my mind, that requires tying any approval to plans.
Okay, I don't have a specific objection in this case. I just thought it was usual for lot width and lot area to not tie plans to the approval.
Well,
but maybe that's changed.
apparently not so. Anyway, so we will tie that to
Okay, that's fine.
approval tied to plans. All in favor of this application as presented today? All right. And myself, your application is approved. Good luck with your project.
Thank you. I'm on the next agenda item also, so I don't know.
Yes, you are.
Okay, but thank you.
But don't go away.
I didn't want to get hung up on because yeah.
And we're going to have to do this. The next item on the agenda is, well, actually, next two, items 3 and item 4, correct?
Yeah, there's lots that are side by side, but they're separate applications. Yes.
Yeah. Okay, so 4. Have to do this application separately. Again, the oath. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
Thank you. All right. Item number 3 on the agenda, 189 Hinchy Avenue. Minor variance to permit reduced lot width, lot area, and southerly side yard setback. It is proposed to demolish the existing dwelling and to construct a 3-story long semi-detached dwelling. So if you'd like to proceed, Ms. Murray, on this application, please.
Yeah, so this is adjacent, I mean, just for context, this is adjacent to, but a separate developer from an application that came before the committee about a year ago, actually 185 Hinchy, where the application was actually refused and we made some changes to rear yard setbacks, removed balconies, shortened the unit. And these two are 189, I think is the first one on the agenda that I'll speak to specifically, but these have taken, I guess, the learning from 185, and it's a different developer, but it is the same home designer, Andre Theriault. So they've created a different, and the rendering on the screen is helpful. They've created a different materiality and color scheme that I think complements, but is different from 185. I have visited the site a few times, and now that 185 is built, I think we could definitely say that it fits in fairly well with the context of the street and the scale. It does not read very tall. The way some other triplexes that have been built on the street do read quite tall. So this is a new proposal, but it is helpful to see the context of one that has been built before. So the setback request. So I did submit, there's a site plan, I don't know if we could put it on the screen. I did also submit a plan that shows the two beside each other, but this is fine. The two proposed site plans. So basically the requests are, I'm going to just flip, but on the side yard setback, I wanted to make sure I addressed it specifically in relation to the two buildings. So on there's the three variances are for lot width to 7.65 from 10.0, which is required for a long semi. But a detached house in this zone is 9. So the minimum lot area is 228.5. 270 is required, and an interior yard setback of 0.61 on the north. Sorry, on the south side of 189, whereas 1.2 is required. So the narrower setback for these two homes will be between the two properties, so that the setback from existing properties will maintain the zoning of, it's a 1.2 minimum zoning, but actually 1.5 is provided at the street, and the servicing is in the 1.5 meter setback, and then it steps back to 1.2 at the sort of rear of the building. So there's no request for any rear yard setback reduction. It's lot width and lot area, which makes the building basically just shrink in size. And then the interior side yard from 0.6, and 1.2 is maintained on the outside.
That flag portion of the lot at 1.5 meters, is that a wide enough piece of land to be able to get things like furniture in and out of the semi-unit at the rear of this property?
Yes, it is. Yeah.
Because I'm assuming the door is located at the in the area where the width is at 1.5 meters.
Yeah, it is. But 1.2 is, I mean, 1.2 is allowed in the zoning for a semi, but 1.5 is, I think, allows for the servicing the sewer to have enough of a setback from the rear building. Yeah, 1.2 is 4 feet. So
I'm talking about where's the door on this property? The property at the rear on this one, in the 1.5 meter setback.
it's in the 1.5. Yeah.
Okay. You have to have sufficient space to be able to get things like furniture in and out of a dwelling. Do you not agree?
Yes. Yeah, I think that's more.
That's sufficient that's sufficient in your opinion?
Yes, 7 feet, 1.5. Yeah.
Okay.
So in reviewing the official plan, it is in general conformance with the city's official plan, having reviewed section 2.51 specifically and 4.1. With the zoning bylaw, we've sort of identified in a little bit more detail about general conformance with the zoning, just noting that a lot width and lot area variance would also be required just to bring the current lot in conformance for a detached dwelling on the property. So a lot of the fabric in this area of Mechanicsville is 7 to 8 meters, and the zoning requires 9 for a detached. So a variance would be required for any redevelopment of this property. So same with the minimum lot area, it is a small variance, and the interior side yard setback we've discussed, so it's 1.5 stepping back to 1.2, and they're not proposing to sever this front to back semi now, or it's not envisioned to be severed in the future either. So
I'm assuming there's no parking on site?
There's no parking proposed, no.
And so where are the residents going to park?
Well, I think this development, along with others in the neighborhood, are being proposed without vehicles. So I'm working actually on a project on the south side of Scott Street that has 16 units with no proposed parking, and staff is supportive of that too. I think it's a risk in some ways by the developers to develop rental property without parking, but I think there's a market for that. So I know they're also looking at permitting on-street parking, but that's not currently available. So it's basically just a development with no vehicles attached to it.
And that rear lane is usable, or is it overgrown?
I think it's usable in some sections. I don't think they're not as this developer's not assuming they have access to that lane for vehicles.
It won't be a travel laneway in the backyard of this long semi disappears and ends up as 2 parking pads. In other words,
Lane, it's an open down Lindale, which is to the north. It is an active lane. I'm not sure behind these 2 properties whether it's traversable right now.
all right. Mr. Wilder, did you had a question? Comment?
So
Oh, sorry, Miss Marie, I didn't realize.
All 3
I realize, Ms. Murray, you were involved at least twice, just once, I guess, with the application next door at 185 before it was put over to another agent when it was brought back with the final changes. I walked the laneway and I looked at the property next door, which, at the back, it's finished now. They just got gravel stone, basically no landscaping whatsoever, right to the laneway. Very disappointing. I walked further on to where it dead ends, where your client's property is. It's just a wheat field and behind now on the laneway. It was mentioned, in fact, that there was an agreement among the owners to maintain that laneway for snow removal and whatnot. I think that's something you had mentioned. There was an agreement. I don't know, not even making any mention of that right now, but my real concern is you show a photograph of the 3 properties next to each other, 185, 187. You show, or at least the architect shows an imprint of a tree. Each of the 3 properties. Obviously, you're not dealing with 185 today, but certainly for your 2 properties, the way it's going to be landscaped at the rear, that's a concern for me. But more so, I still, I have an issue with the 0.6. What would happen if, in fact, you went and you tried to comply with the 1.2, notwithstanding what we agreed to at 185? Is it going to just remove some of the square footage of the units?
Yeah, certainly it removes square footage. So it's a difference of 2 feet. So I think it makes, and that was the discussion I think we with 180 workable floor plan the way it is now, but it's quite small. I mean, it's an urban, making that 2 room size is basically almost unworkable. And certainly it's a common setback. You see on detached homes, 0.6 and 1.2. It's a requirement on these long semi to have 1.2, I think, to allow additional access. And also we've provided this 1.5 in the front, which is not required in the zoning bylaw, which gives more space for access to that exterior wall, but also for the services. So I think 0.6 is sufficient with 1.2 on the other side.
Well, I don't necessarily agree, but thank you.
Thank you.
You're aware that there are no conditions that are being asked for by the department? I'm assuming. All right. Standard request from Hydro Ottawa regarding servicing meter must be installed a minimum 1 meter clearance from the property line.
Yep.
And I believe the
So they have a bump out. I mean, just
And the Mechanicsville Community Association is in support of the application, I take it. You still there, Miss Murray? Everybody else hear me? Are you still there, Miss Murray?
That had been discussed, but yes, it's a
Yeah, you're aware of Mr. Max's comments regarding the narrow alleyway and the height of the new roof towering over the neighbors. I'm assuming you've seen that letter.
I am. I have. Yeah.
Could you
I
kindly respond to
believe it's in relation. Yeah, I have not spoken myself to the owner or the lawyer, but my client has spoken over the weekend to the property owner to the south. I think the comments have been written about 189, but I believe they're intended to be written about probably 191. And I think there was actually, I think they're just possibly mistaken about the setbacks being requested. So they've indicated that they would be supportive of a 1.2 meter setback from their property, and that is what we're proposing. But that they would have concerns with a 0.6 setback from their property. And we're in fact proposing a 1.2 meter setback on 1.5, stepping back to 1.2 on their adjacent property line. So I think there was possibly just a misunderstanding maybe of the plans. I'm not sure.
And you're aware of Mr. Max's comments regarding the roof of the new house, as he says, will effectively tower over both my client's side alley from the street to their backyard. So his clients have concerns regarding snow coming off the roof. I'm assuming roof melt as well, and the narrow separation distance between the units. So if you'd like to, I don't know if you've spoken to him or not, but have you any comments regarding that concern that's been raised by the lawyer?
Yeah, well, I don't know if you heard what I just said, but basically they were objecting to a 0.6 meter setback, which is what we're proposing for 189 on the south side. But on 191, we're proposing a 1.2 meter setback on the south side. So my comment would just be that
Okay.
I think they misunderstood the proposed variance. I mean, in relation to that, I would say that their property, if you look at the survey,
Yeah.
I don't know if it's possible to put it on the screen, just the legal property survey shows quite well the 3 properties, and it's fully built out. You know, it sort of looks, I guess, like a detached home from the street, but it's a kind of large garage operation, and it's fully built out from the road back to the lane. But I think the comments were in relation to 191 Hinchy, which is the neighboring, which is the next item on the agenda.
It specifically references 189.
I know, I think that, well, my assumption, and I would let them speak to it, but is that they may have looked at the application for 189, where we've got 1.5 on the north side and 0.6 on the south, and understood that to be proposed for 191, but it's a mirror image. So
Okay.
I hope that it's just a misunderstanding.
Okay. All right. Are there any other comments from the members? Mr. Wilder, please.
What I'd like to know, Ms. Mary, is what is the separation distance between 187 and 189? Just mention that to me, please. Is there some way that could be widened and not have the, you're asking the 0.6 and 0.6 for each property. Is there some way that we could, since your client's going to own both properties as rental units, I imagine? I guess that's another question I have. How many tenants will be in each of these two buildings, since we're talking already about the 2 buildings?
Okay, there's a few different questions in there. So they're not proposing to sever them. So somebody could own the front unit and rent the back unit. There could also be secondary dwelling units in it. So you could have up to 4. I mean, you could have any number of people that would rent a unit, but you could have up to 4 units on each property, or 2. But I'm not sure if you're asking me ownership, or you could have ownership of either of these buildings with someone living in it and then renting out the back unit. Or you could have up to 4 tenants. It depends. I'm not totally clear on that. If the first question, I think, was about the setbacks. 187 is not, there is no 187, and I know they referenced that in their letter. I believe they're referring to the garage, which is south of 191, which I would assume would be an address in the 190s. That is a proposed setback of 1.5 and 1.2 from the property line. So are you asking me the difference between the existing house wall of the garage and the proposed, or because 187 doesn't, there is no address of that.
Sorry, in between 187 and 189, your two clients, your client's 2 properties, the separation distance there.
Okay, so 189 and 191 are the 2 applications that are before us today. So they're 0.6 and 0.6. Is that the question? So there's 2 feet on each side. There is no 187. The lawyer referenced 187 in their letter, but there is no. So the 2 current applications that are before you today, it's a space of 0.6 and 0.6 between them.
The other question I have is, you talk the secondary dwelling units. These are being built, there's no basement, no ability for a basement unit here because it's being built slab on grade, right? So in terms of secondary dwelling units, does it actually meet, if you put in 2 additional units, does it meet the zoning requirements of secondary dwelling units in this structure?
It does, yeah, because it has to be 40%, I think, of the upper floors, because it's not below grade.
Yeah.
It does meet the definition, yes.
Any further questions, Mr. Wilder? Okay. All right. I think Ms. McLean had a comment regarding right-of-ways.
Just following up on Mr. Wilder's comment about the reduced side yards between the 2 proposed developments. Has there any consideration been given to creating a mutual right-of-way so that one development can go over the side yard of the other development? In other words, create a sort of a 4-foot right-of-way between the 2?
It hasn't been proposed. I mean, it is one ownership. I mean, it's under 2 different titles. One is multiple owners and one is a numbered company. But it's the same, a number of the same individuals. No, it hasn't been discussed. I think 0.6 being a zoning setback that's allowed for detached, it is common to have that as a setback, a 2-foot setback. Are you thinking of that as some kind of condition?
Not a condition. That would have to come from you as an agent. Just the concern, I guess, is with the reduced side yards. And if someone was to put a fence down that side lot line, could you get a ladder up to maintain a wall board on the 3rd floor or something like that? So if there was a mutual right-of-way, it gives you that ability to maintain the walls for each of the buildings.
Mm-hmm. Yeah, I mean, it's not part of our proposal. right now, I don't think they had a concern about maintenance of the two buildings with the 2-foot setback.
Okay.
I mean, I could
You raise this with your applicant possibly?
yeah, they're actually on, I mean, they're on the call, but I don't think they have participant status, so that you can't hear them, I don't think.
Right.
I think it is, I mean, it's a unique situation because it's the same property owner on both sides currently.
Mhm.
But it wasn't part of what was proposed, and I don't think, strictly speaking, it's not necessary on a single detached home. But we could discuss it.
How
Okay.
would you maintain the third floor wall on that side?
I'm sorry, how would you maintain it?
If you had to do a repair,
Was that the question?
yes.
Yeah. Probably with the tall ladder. Operation, I don't envision at all you have a fence between those two properties. There probably has to be cooperation between the neighboring property owners. But we can discuss that, whether it's something that the committee would feel more comfortable if that was formalized in an agreement on title. So that would be, I guess, like a shared access, the maintenance agreement.
Well, I think it would have to be a formal right of way, and it's not part of this application. It's just a comment about a concern with a reduced side yard of 0.6 meters. So I'll just leave it at that.
Yeah, I mean, an access easement is what's used on townhomes, for example. People access through each other's backyard. I don't think it needs, defer to others, but I don't think it needs to be a rule, potentially.
Okay. Any other questions, Ms. McLean? Any other members have any comments, concerns? Are we prepared to vote on the application as proposed?
Mr. Chair? Mr. Chair,
Yeah.
Glenn Max speaking. I'm the solicitor for,
Mr. Max.
yes, could I
We've read your letter.
address you? It's been very difficult to hear the feed here. And I am totally unclear on what the last witness's position was on the narrowing of the 1.2 setback that we have been objecting to. Could I have that clarified at least?
Ms. Murray?
Yeah, so the agenda item that is up right now is 189 Hinchy, and I believe that your comments were intended to relate to 191 Hinchy, which is the one to the south,
Correct.
the one that's adjacent to the garage. So I do you think it would be relevant to discuss those concerns on 191? I'm happy to answer the specific question right now, but I think it's relating to 191.
I understand that she's not delivering a final view on this matter at this point.
She has one more application to deal with, which is 191, isn't she?
Sorry, sir, we just did not get the feed through clear as what was being said here.
Did you not
The
hear?
comment,
Go
yeah,
ahead,
the
Ms.
comment, I'm gonna guess, maybe go ahead and answer the question, but the comment about the 0.6 meter setback reduction on the property adjacent to the garage is proposed to be 1.5 and 1.2 on that property line, but it's relating to 191 Hinchy, not 189 Hinchy,
I understood her that she wasn't.
which is what we're discussing right now.
So you have to add. Wrong. You have to put it for the one, what addresses you
Yeah, I'm sorry, I apologize, we're still puzzled as to the view on the south side between 189 and our client's property at 187. The proposed cutback of the 1.2 to 1.6. I'm not clear as to what the view was on that.
Ms. Murray?
I'm not sure. If you are facing the properties from the street, if you're standing on Hinchy looking at the properties,
South
189,
south wall of the applicant's property and the north wall of the Donatucci's property.
yeah, this, I don't know what the municipal address is of the garage.
I didn't understand it to be the garage. But go ahead.
But it is sharing a property line with 191 Hinchy, not 189 Hinchy.
Which is to the south.
Mhm.
Sorry. There's considerable confusion here. I apologize for holding things up. But our submission said if you're standing in the street facing these properties, looking, the left-hand side of the applicant's property or south side faces our client's north side. And there was a proposal to narrow the setback from 1.2 to 1.6, causing, in our view, narrowing that would render problems and matters non-functional. I understood that the other side was being talked about, the setback. But I'm talking about the setback here on the south side. And I'm just not clear as to what is either being approved or not approved or possibly not being dealt with at this point.
Yeah, the proposed, there's no proposed variance on the south side. It's matching the zoning requirements on the property line that's shared between the garage and the proposed. There's
Well, I don't know. Remember,
no proposed variance along that lot line.
if you're looking at the property, Mr. Max,
We have a schematic we can put up here so that we can all talk about the same thing.
we're not talking.
I don't think we're talking.
Yeah, I know on page 10, the planning rationale, it shows all three.
Are they reducing it to 0.06 or not?
Because we're just trying to find out, are you proposing to allow a reduction to 0.6 or leave it at 1.2? That's all we're asking.
We're not asking for a reduction on that shared lot line. I mean, somebody else, maybe city staff could comment on this, but we're not asking for a reduction on 191 on the south side.
Bring it across, Mr. Max.
What we're dealing with today, Mr. Max, a variance C to permit a reduced southerly interior side yard setback of 0.6 meters, whereas the bylaw requires a minimum interior side yard setback of 1.2. So we're dealing with the south side of the property only and a reduction to 0.6 from 1.2. And this is the side of the property which is immediately adjacent to 191 Hinchy,
Right.
which is the next application we're going to be dealing with.
Wait a second.
It is not adjacent to 185.
Or 180, 187 is our client's property.
Yeah, no, wrong, other side of the property. We're dealing with the
That is not-
south side of the
not
property.
listed.
We're not dealing with the north side of the property. There are no requests for variance on setbacks on the north side of the property, only the south.
Sorry, there is a request for
The
variance.
garage,
There's not.
There we go. That plan shows. The plan on the screen right now shows 185, which is the previously developed property, which is now almost completed construction. In the middle where the star is 189. And on the right side is 191. So those two are before the committee today under separate agenda items. And to the right, which is not shown here, is, I believe, the client of Mr. Mack. But there is no variance requested on that side. There's a variance request element parcel. So when I read the letter, I assumed there was just some confusion.
Well, that's what we're concerned about.
So your client, Mr. Max, is at 187, which is on the south side
That's right.
of 191. So,
Is on the 191 side. That is correct.
right. So one property over. And that's the next application we're going to be dealing with, which is 191.
Oh, I'm sorry, Mr. Chair.
Okay. So we'll hear from you on 191 and listen to your concerns there because there is a request for reduction there.
There is a reduction there.
Yeah. And on that, you have our written submission, which specifically sets out the objection and the effect we feel is going to be brought about.
All right.
And I'd be interested in hearing then from your advisor as to what their position is on that.
I didn't quite catch your last comment, Mr. Max. What's on?
I said we're interested in, I agree with you that we're dealing with 191 south side.
Yeah.
And our client's property north side. I got it correct now?
All right. Okay, so
And we've objected. There is a request to reduce from 1.2 to 0.6 on that south side, on the setback. And we are trying to clarify what is the position of your speaker and advisor on that portion.
and I believe Ms. Murray has explained that. All right. On the,
Could I suggest that we talk about this under 191?
well, we still have to make a decision on 189 right now. And these are, we're at a lot width of 7.65 meters. I'm going to reduce lot area of 228.5 rather than 270. And to permit a reduced southerly interior side yard of 0.6 meters, whereas the bylaw requires a minimum interior side yard setback of 1.2 meters for a semi-detached dwelling. Any other comments from the
I think, Mr. Chair, I'd like to reserve on both these
vote on the
applications.
variant? All right,
Yes, Mr. Chair, I'd like to reserve on this as well.
all right. We will reserve therefore on this application, Ms. Murray.
I'd like
And
to
you will
reserve on
receive
both of them.
the,
I'll mention that now.
Yeah, well, we haven't heard the second one yet. We'll reserve on 189 and you'll have our decision within 10 days. So
Thank you.
now we'll move to 191 Hinchy, and I'm going to have to once again administer the oath. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
All right. So this application is for the property immediately to the south of the previous application at 191 Hinchy. Minor variances to permit reduced lot width, lot area, northerly side yard, and front yard setbacks. Proposed to demolish the existing dwelling and to construct a 3-story long semi-detached dwelling. So if you'd like to give us a brief presentation on this application, please, Ms. Murray.
Yep. So I'm just opening my file. So this is very similar in explanation to the one to the north. This does have an additional variance requested for front yard. Zoning bylaw in the mature neighborhood overlay calculates this proposed front yard setback is consistent, in fact, a little bit of an increase on what is currently there. And it lines up the two adjacent properties to each other. So I'll maybe just start with the rationale for that piece, because the remaining, I think, discussion is very similar to what we just went through for 189. So in reviewing the front yard setbacks for the area, the property seemed to be either very tight, 1 to 2 meters from the front yard setback, or a few of them were actually significantly set back. So 4, 5, 6, 7 meters, which is, I'd say, very ad hoc. There's just once in a while a property that's set back. So it is consistent with the predominant character on the street to have the frontages either very close to the front yard, or to sort of have, I think probably traditionally a front yard and even front yard parking that had them set back further. So we've asked for the reduction in the front yard setback for 191, which I had discussed with staff, and from a, I guess, planning policy perspective, they sort of agreed with that conclusion. The applicant did discuss this front yard, not just for this property, but for both properties, with the community association, and they did commit to providing some soft landscaping in the front. There's not a lot of space, but there is sufficient space to provide some soft front yard landscaping, as is shown on the artist rendering, which I think was up initially. You can see that there's enough space to provide a little bit of planting. So that was the main concern, I think, on the front yard setback from the community association perspective, was that some green could be provided. So if you look at the photographs and the planning rationale of the site today, there is a strong sort of frontage along Hinchy Avenue of front yards. So otherwise, we feel that the 4 proposed variances are in general conformity with the official plan, are compatible. They are in general conformity with the zoning bylaw. They're minor in nature, and they are appropriate for the development of a lot. We didn't discuss as part of the other file, but certainly infill and intensification in such close proximity to the Tenny's Pasture LRT station and the Bayview LRT station. This is really close to both of those. You know, is under the city's current official plan is encouraged, and is also, I think, further encouraged under the new direction of the city's official plan. Sort of clarify the discussion about the shared lot line also with the adjacent property. If there's any specific questions from the committee.
Beside it, you're going to have a 1.5 meter walkway on the south side of the property going back to the entrance to the rear unit, and then the side yard is reduced to 1.2, which is the minimum under the bylaw.
Yeah.
And so the north side of your property is where the side yard reduction is from 1.2 to 0.6.
Correct. Yeah.
Which means there'll
And
be and this is why Miss McLean brought this up, which means you're going to end up with a 1.2 meter separation distance between the 2 new homes.
Yes.
The south side of one and the north side of the other, which is why the right-of-way issue is, I think, is something that would be worthy for you to discuss with the property owner. Okay. Any
yeah, I just wanted to mention the one, we didn't discuss it specifically. The 1.2 comes out of the semi-detached requirement, and I think that is a requirement because you have only one side of your property. So in these cases, we do have 1.2 plus 0.6 under the same ownership.
Yep.
And that is common for detached houses to
Yep.
have.
And the rear yard is going to be treated in the same way as the property beside it. I would assume there won't be parking there.
Correct. Yeah. And I would say on the question, it's not relevant directly, but 185, which is under construction, is not, you know, Mr. Wilder had mentioned that it's gravel. It is not, I'm not involved in that project. It's possible that the landscaping just hasn't been done, because it was shown as landscaping on their permit applications.
All right. Okay. Correct me if I'm wrong, but I think I remember seeing that the Hindenburg Community Association requested that the air conditioning units on these new houses be screened to reduce spillover noise from the units.
Yeah, so there is a bump out on the 0.6 and 0.6 side. There's a utility bump, mechanical bump out into the unit. And so the client, I guess, is currently looking at, I guess, if they're going to include air conditioning, whether they can accommodate it in that area. But they did discuss that themselves directly and attended a community association meeting. So they're okay with that requirement.
So they've come, the association and the applicant have come to an agreement on those matters.
Correct. Yeah, they've discussed it directly. Yeah.
All right. Okay. And again, there are no conditions being asked for by anyone. Building Code Services, once again, obtain a demolition building permit prior to demolition of existing dwelling, and the standard comments from Hydro. Mr. Max, do you have any comments on 191 Inchy? Not. All right, I guess not. I think both Ms. McLean, comments?
I just asked the city planner, why is it that for a detached, you can have a 0.6 meter side yard, but when you're putting on a long semi-detached, the bylaw requires the 1.2 meters on both sides?
Through you, Mr. Chair, I believe the reason for it is because when someone is developing a long semi, the standards are the same as a semi-detached dwelling with the exception of the lot area. For a long semi, the lot area is the same as a single detached. And the reason for having the side yards at 1.2 and 1.2, it's because technically there would be 1 yard if this was a traditional or semi side by side being at 0, while the other ones is 1.2, 1.2. As Mrs. Murray has said, single detached have 0.6 on one side and 1.2 on the other, but because technically semi-detached are together, the 0.6 meter setback is eliminated by being attached to the other home.
Thank you.
All right. Any further comments, Ms. Murray?
Maybe just on that, I would say that when the long semi-detached was brought in, I think the city looked to integrate it into the existing zoning that existed for semis and detached, but they are looking, I think, under the updates to Info 1 and 2 to create different requirements specific to long semis. And so I do think that this is entirely appropriate for a detached house under a single ownership.
Okay. All right. All right. Any other further comments in the Ms. Oakesharo, you have a question, comment?
Through you, Mr. Chair, I'm just wondering if, Ms. Murray, you considered any other designs that would respect the required front yard setback?
We did. I mean, the zoning setback really came up as we reviewed the zoning because the existing house is quite tight to the street, and so were the two adjacent to it conformed with the front yard setback. So we did look at, we would have basically had to reduce the house by 4 meters, and it's not workable. So you would lose that unit basically. You would lose the opportunity for that infill unit.
Thank you.
All right. And the house that's on that site right now is built right to the property line, correct? Pretty much.
It's 0.5. I don't have it in front of me. I've just switched screens, but I think it's 0.5. It's less.
Yeah. As are a lot on that side of the street that are currently in existence. Okay. All right. Well, thank you, Ms. Murray. I think both Mr. Wilder and Ms. McLean would like to reserve on this, and I think I concur, and so does Ms. O'Sharon. So we will reserve our decision on this application as we did with 189, and you will receive the decisions on both of these applications, our decisions on both these applications within 10 days. Thank you very much.
Okay, thank you very much.
Okay. Next application we'll hear today is item number 5 on the agenda. 345, 347 Athlone. This is a consent to subdivide the property into 2 separate parcels to establish separate ownership for the existing semi-detached dwelling. And the Mr. LeBeau is the agent for the applicant. Is he there? Mr. LeBeau, we need to go through the oath regarding the signposting. Are you there? Can you hear me?
Can you hear me?
Yes, I can.
Okay, I was trying to start the video, but it doesn't want to go. So I guess we'll.
All right. Could you give me your address, please, Mr. LeBeau?
It's 345 Athlone Avenue.
Okay. So I have to administer the oath regarding the signposting. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
Yeah, I do.
All right. Thanks very much. This is an application to subdivide your property. This is an existing semi-detached dwelling. Do you have anything at all to add to what we received in our package?
No, everything is there. I guess I was done under the building permit that is quoted in the application form. So.
Yeah, and you're aware that that the planning department requires the confirmation of independent services, and there needs to be a joint use and maintenance agreement for these properties.
Yeah, we got those comments, and I had some question regarding that. I guess so. The house has been built. The service, the meters was, I guess, provided by the city. So, in terms of confirmation, is it just a written statement that, as per the water bills, these are separate units?
You need to talk to staff about that. But if you're aware of the conditions.
Yep.
And you have to talk to the appropriate staff at
Okay,
planning branch or building code services and get that straightened out. It's pretty simple stuff, actually.
Okay,
anyway.
And the same thing for the other condition regarding the agreement binding the owners for
yeah.
Okay, all right.
And you can talk to staff about the details of that as well. Again,
Okay.
That's pretty straightforward stuff.
Okay, we'll do.
Anyhow, this is a consent application to sever a property. I don't see any need to go through the process of plan of subdivision for this property. I don't think the rest of the members would probably agree with me. Hopefully they will. Are we all in agreement to sever this property as the proposal has stated? All in agreement? All right, Mr. Lowe, Your application is approved, and just contact staff regarding Juma and the independent services.
Great, thank you very much.
You're very welcome. Next application we'll hear is item number 6 on the agenda, 760 Ben Street. This is another consent application to subdivide the property into 3 separate parcels of land, proposed to create new parcels of land for each of the 3 two-story townhomes currently under construction. And I believe Mr. Segreto is the agent on this application. Are you there, Mr. Segreto?
Yes, I am.
You are. All right, we have to go through the solemn oath regarding the signposting before we begin. Do you solemnly swear or affirm that this notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I swear.
Okay. All right. So as I mentioned, this is a consent to subdivide the property into 3 separate parcels of land. One thing I noticed on your application is you speak to demolish existing building and subdivide the property into 2 separate parcels of land.
I picked that up as well. That was a typo. It should be 3 separate parcels of land.
Okay. So if you could very briefly explain this, and I think Ms. McLean has questions regarding the registered plan.
Basically, it's an existing it's an existing 3-door row, 2-story, which is under construction. I believe there's an partial occupancy already in place, and we just want to go for separate ownerships on all 3 different parcels of land. We've created right away off to the one side, so we can have access for the middle unit, and in the back of the property, you can clearly see there's parts 3, 4, 5, and 6. Which will be the easement. I believe there's a utility easement in the back, but we have access off to the one side for part 6 of the middle unit.
Okay. Ms. McLean, you had a question?
Mr. Segreto, those projections at the front of the building on part 1, this proposed severance line seems to go through, is that a column or a wall?
What they are, I believe, is that it's just a column for the porches that we have in front, and they're permitted. There's no problem with those. As you can see, the plan that's in front of you is the as-built plan as well, and they're permitted to project into the front yard.
So part 1, the owner of part 1, its column is extending over onto part 6's property. And then similarly on part 8, the column there, how would you maintain that given its close proximity to the proposed severance line with part 6?
Are we talking about, I think that's on the line. He's showing the line there that it's totally on the column that we're talking for part 2. It is on his property there. It's not encroaching onto the other side. Plus there's a joint use and maintenance agreement that we have on this as well that we've ticked off.
Okay.
So would the joint use and maintenance agreement allow the owner of part 1 to go on to part 6's property if they had to maintain the wall of that column or paint it or?
I believe so, Ms. McLean, because in the past what we've had is at times we've had roof overhangs that encroached roughly 12 inches or so onto the other part. And I remember dealing with the solicitors, in particular, Mr. Frank Falsetto, that addressed that in a letter for us when we've had that issue come up. And I believe if there's an issue on this column over here, that we would be able to address that as well.
Thank you.
Any other members have any comments or questions regarding this application for consent? Are we all in agreement regarding this to grant this application of consent as proposed with the explanation? All in favor? Your consent application is approved, Mr. Segreto. Thanks so much.
Thank you very much.
You're welcome.
Thank you.
Next application before us today is item number 7, 287 Atlantis. And this is a minor variance application to permit a reduced northerly side yard setback. It's proposed to demolish the existing detached garage and construct a 2-story addition located on the north side of the existing dwelling. The ground floor will provide a new attached garage with entry to the existing mudroom, and the second floor will provide additional living space. Now, I believe Ms. Thompson is the applicant for this the applicant's agent for this.
Yes, I am, Mr. Chair.
Okay, we have to go through the oath regarding the sign posting before we begin. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
Okay, if you could give us a brief presentation on the application, please, Ms. Thompson.
Okay, if we could screen share.
And perhaps you may want to make a comment on the impact if the applicant simply complied.
Okay, yes,
With the zoning bylaw.
I will do that. I just have a few context photos here, just showing that it's a street with a mix of singles and semi-detached with a combination of driveways and garages out front at the side and detached garages at the back of the property. I think showing the existing house front and the garage now at the back of the property, and then looking in the backyard.
Okay.
Move to the next. And then some more images along the street. Next. And there was a letter received from the neighbor to the west. And so we've added some photographs that show the situation there. You can see the bungalow to the left, the perennial garden that was mentioned in the letter. And then there's about a 2-foot high log retaining wall, the neighbor's property sloping towards that. And there were drainage issues that were mentioned in the letter, which we just wanted to show in this illustration after a rain, that there is water that's seeping from the neighboring property through the retaining wall onto the driveway, and our new design has a few issues to address that. And then I think on the next photo we have some detailed images of what where the neighbors' windows are positioned. The one on the left is the kitchen window that was mentioned. Then there's a door which opens off the kitchen, we believe, and then a bathroom window to the right. If we switch to the next illustration, and the next page, that should be the site plan.
Yeah.
What we're requesting is a variance of 0.91 meters from a required side yard setback of 1.2 meters. Yeah. Because the house is situated at an angle on the lot, this would result in a setback of 1.08 meters by the time it reaches the back of the property. And the reason we've requested that minor variance is we have looked at options that didn't require the variance. Okay. But what happens is we have the chimney projecting out, and so the variance and because of the angle, the variance we've requested is the minimum we would require to have a standard 8-foot garage wide garage door at the entrance, and then a 6 or 7 inches either side to allow the garage door mechanism. So that I'll show you a little later on. We did look at we have shadow drawings for a version that didn't require the minor variance, but had some other impacts. What we were hoping to do was push the addition. We set it back from the front of the road so that the garage is secondary to the house and is in line with the neighboring dwelling at 285, so that it's not prominent. But we were hoping to move that forward in order to reduce the length of the driveway and to provide more green accessibility or green space in the backyard. I think the next drawings show the plans, which we could skip through quickly and maybe just take a look at the elevations. So this is from the front, showing the new garage. What we've done is create a low roof at the front and stepped that back to match the character of the existing house, and also to reduce the bulk of the building as much as possible for both shading reasons as well. The next elevation shows from the side of the building. You can see the step back. There used to be, privacy was mentioned by the neighbors as one issue. There used to be a window on that side of the house, which has now been covered over. And so there are no windows overlooking the property, as you can see on that side of the house. And then I believe we also have a back elevation.
Okay.
And then that's the other side.
And that's the rear.
Yes. We've taken a look at the 4 tests, and we believe that it does follow the general intent of the official plan. It's a general urban area, and it matches the use and the urban context. We believe it maintains the general intent of the zoning bylaw. There's a single variance that's small in both impact and in actual number. And we believe it's desirable for the development of the lands. It replaces an old garage, creates more green space, and builds on an area that was asphalt while respecting the basic massing of the street and the required setbacks. And the variance is very minor difference from the 0.91 and 1.08 meters to the 1.2 requirement. I think I also have, once we received the letter from the neighbor yesterday, we very quickly did some sun studies, because one of the major concerns seemed to be shading of their windows. So I believe those are the next images that we have up, if you'd like me to address those. Here we looked at the existing impact. There's the 1-story garage and the house. We started looking at 8 a.m., which would be a typical breakfast time that was referring to. And so both the garage cast shadows on the ground and the lower part of the wall at 8. And then as you move towards noon, the main house shadow comes around and hits the bottom part of the wall. And then this is looking at the shadowing of the, oh, sorry, if you go back one. Yes, that's back one. Forward. It would be the second shadowing drawing. Yes, there we go. This is the proposal with the variance. And so what happens is at 8 o'clock, the green shadow, the 2 windows and the 1 window and door are not in shadow at all anymore, because we've taken a garage that was closer to the property line and further to the east and removed that. And then there's a shadowing of a bit of the window, but that's at the bottom of the wall. And as it angles up, it isn't shadowing the window that the owners are concerned about at breakfast time. And then similar to what we saw in the existing situation, as the sun comes around during the day, there will be some shadowing of the wall as there is now, but there's actually less shadowing in the proposed version than in the existing. Okay. And then the very next image is looking at, this is the proposal we considered that didn't require a minor variance. And what that meant was we had to push, because the space between the house and the property line gets wider as you go to the back. We pushed the addition back where it would miss the bump out for the chimney. And so in this case, and this is now set back the extra distance so that it complies with the 1.2 meters. And this is the one that creates the most shadowing of all, because especially in the morning, because you have the mass of the garage across from the windows.
So you've addressed that. I think with your comments, I don't think privacy is an issue. It doesn't seem to be. The neighbors are also talking about noise, air quality, and drainage. Any comments regarding that?
Yes, for the noise, we think there's less noise with this addition. There's no windows that can be open. There's no air conditioning. There used to be cars driving along, so lights and cars parked along the driveway, which now will be blocked off by an addition. There's still the air. There's still lots of airflow between the buildings, but a wide area for maintenance. They mentioned roofing maintenance, which can be done from the front and the back.
Okay.
And as far as drainage, we're trying to deal with the water that has been seeping from their property onto the driveway. And our plan is the roof slopes slope to the front and to the back of the house so that there's no additional water being shed. And we're also increasing the slopes down to the street beside the building and to the back so that there are any water that does fall on our property drains directly forwards or backwards on the property, but not towards the neighbor.
It seems to me from looking at the pictures you provided that the drainage problem is from their property to your client's property more than anything else.
That's
Because
the
of the
current
elevated
situation.
nature of their yard. And I'm well aware of what the property standards bylaw says about draining your property onto your neighbors. You're not allowed, period, as you know. Okay, so you've addressed the neighbors' comments then. All right. You're aware of Hydro's comments regarding building modifications and not affecting the accessibility for Hydro?
Yes.
Okay. And also from Building Code Services, they're obtaining a demolition permit prior to demolition of the existing garage and obtain a BP prior to construction, obviously.
Yes.
Okay. I think for me anyway, you've dealt with the impact if there weren't any variances, and it seems to me that the impact would be frankly more pronounced and with a loss of green space in the rear yard. That doesn't have to happen. Any of the members have a comment on this application? Are we all prepared to grant the application as provided to us? All right.
Mr. Chair, no, I'm not voting in favor of this application.
All right. Would you like to explain why, Ms. Sharon? Ms. Luke Sharon?
In looking at the application, it appears to be primarily of private benefit to these homeowners. And I do think that there is an impact on the to the adjacent property that's undesirable. And I don't think that the reduction is minor in this case.
Okay. For the record, Ms. Luke Sharon dissents. The other three of us are in favor of the application. The application is granted. Good luck with your project, Ms. Thompson.
Thank you very much.
Thank you. All right. Next application is number 8 on the agenda, 304 Cumberland Street. And Mr. Simard is the agent for the applicant. Is he there? Mr. Simard, are you there? Can't hear you, sir. Oh, there we go. And you're still muted. All right, Mr. Simard, can you hear me? Still can't hear you, sir.
How about now? Can you hear me now?
Before we begin, I have to administer the oath. Yes, I can hear you right.
Okay, wonderful. So my name is Mark Simard. My wife and I are the owners through an...
Before we begin, we have to administer the oath on the sign posting. So just give me
Very
a
well.
second. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
All right, now this application is a minor variance to permit reduced allowable projection into the southerly side yard. It is proposed to construct a new fire escape staircase on the south side of the existing 3-story commercial residential heritage building, which will connect the 3rd floor to the new rooftop terrace. So please proceed, Mr. Simard.
Thank you. So my wife and I, through a numbered company, we purchased this building in 2014. It came with an existing rooftop terrace for the benefit of the residential tenants who live in the building. There are 5 units, 5 residential units in this building, with 2 commercial units on the main floor. It's at the corner of Murray and Cumberland, so it's really at the northeasterly limit of the Byward Market. There is very little lot area. The building essentially takes up the entire lot that we own. We don't have any parking facilities. There's no backyard to this building. Yeah. So at the time that when we purchased the building, we had written representations from the vendors who had owned the building since 1988, that the rooftop terrace was there when they purchased back in 1988. It benefited from a legal non-conforming status. And despite conducting a number of searches with the City of Ottawa, we were unable to determine when this terrace would have been built. So we relied on that representation to purchase the building with that rooftop terrace. Then in 2018, in July of 2018, we had a fire on the top of, on the rooftop terrace. And we then discovered that contrary to the vendor's representations, the terrace did not benefit from a legal non-conforming status. And we then took steps to make it legal. We had to replace the roof as a result of the fire. So since that time, our tenants have lost the benefit of the terrace. They don't have a backyard where they can spend any time outdoors. So this really was their backyard. So we started taking steps to render the terrace legal. It has not been rebuilt, of course. Right now we've had the roof replaced. In the course of applying for the building permit, we realized that we required a minor variance for that staircase that would serve both as a fire exit and access and egress to the rooftop terrace. Now, part of the building was built, we believe, in the early part of the 19th or 18th, or that's right, 20th century, so in 1908. And we understand that the fire escape is probably original with the building, but we have no way of confirming that. The fire escape currently goes from the west side of the building and wraps around to the laneway, which is between our property, 304 Cumberland and 308 Cumberland. There's a in the course, in my documents, I have, sadly, I don't have a copy of the binded document that I have left with you, but I do have, so that's the front elevation of the building. Okay. So you'll see on the left side of that image, the existing staircase, okay, which starts in the back of that building and wraps around to the left side of the building, where you see on the left side of the building, we have a laneway between our building and our neighbor's building. The laneway benefits both owners, and there are respective rights of way registered therein. The existing staircase starts at the second floor, as shown on that image, and stops at the third floor. The proposed riser that we want to add goes from the third floor to the roof. So there currently is an existing stair exit or fire exit on that left side of that building. Okay. And so it certainly has no impact on the laneway on the right of access to the building. What you're seeing now on that image is the north side of the building. Our application does not relate to that side of the building. It's more on the south side, or it is on the south side. So on this image, we'll see the elevation for the south side of the building, which is being impacted, or for which we require the minor variance. see on the left side of that image the existing staircase that wraps around to what we're seeing now to the second floor. It goes from the second floor to and currently stops at the third floor in that center window on the top.
Okay.
And our proposed minor variance is to add that existing riser on the top right to reach the roof.
Okay.
And again, it has no impact on the alleyway, which is from that side of the building to our neighbor's property further to the south.
Okay.
The minor variance, we've provided a building location survey from Dutrazak Surveying. And that reflects the top view, if you will, of the existing metal fire exit with the proposed metal stairway, the proposed riser that we want to add from the third floor to the roof.
Yeah.
And it shows that the bylaw provides for a minimum setback of not closer than 1 meter to the lot line.
Mm-hmm.
In our case, we're going to be encroaching into that setback by 0.5 meter. And if you have Mr. Dutrazak's plan, you'll see that we want to, that existing or the new riser that we're adding is going to be the same width as the existing risers that are already there, which according to Mr. Dutrazak's plan are 0.77 meters in width, leaving 0.5 meters to the southerly lot limit.
Okay. Right.
Now, in terms of the tests under the Planning Act, we believe it is minor. It has no impact on the neighbor. And I've already spoken to the neighbor and advised him and provided him with copies of these plans. He had no questions and said, thank you for providing me with the information. It will have no impact on the existing right-of-way, which is between both buildings, because it's basically the minor variance, the installation that we're putting in is from the third floor to the roof. And so it has no impact on the alleyway itself. Is the application desirable? Well, obviously, it's for the benefit of our residential tenants. It certainly will improve the quality of their life, and they don't have any balconies, and nor is there a backyard to our building. And so this was their backyard. It was the rooftop terrace. Does it confirm or conform to the general intent of the zoning bylaw? My understanding is that the bylaw provides that projections are permitted, provided that there's no disruption of access to the side yards where those exist. And of course, our proposed riser, as I just mentioned, doesn't remove any access and is in fact inconsequential. Does it conform to the general intent of the official plan? My submission is that the proposed riser does not change anything in the official plan designation and has no impact thereon.
Has your terrace design been approved, or is this waiting for us to approve this?
The building department has approved our terrace and the plans. We've got engineering plans. We've got BCIN designer who's designed everything. Everything has been approved. This is the last hurdle for us to go ahead and get our building permit.
So you'd appreciate it if we didn't reserve on this.
So, well, my tenants more than I would, but yes, we certainly would.
All right. Do any other members have a question regarding this application? To allow the tenants to enjoy the roof of their building? All in favor of the application? That's divided. Good luck with your project. Approved.
Thank you, sir. Thank you very much.
You're very welcome. The next application on the agenda is item number 9, 92 Ruskin Street. And this is an application for minor variances to permit reduced rear yard and interior side yard setbacks, and it's proposed to construct a new detached 2-car garage in the same location at the rear of the existing dwelling. And I believe it is Mr. Gobet is the owner, and is he available?
I can't, later. The host has asked you to start. Okay. Hello?
Yes, Mr. Goulet?
Can you hear me?
Yes, I can. First, before we begin, I have to administer the oath regarding the signposting. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
I do.
All right, thanks very much. All right, if you'd like to provide us with a presentation on your application, please.
My request is for a minor variance. We have an existing garage, detached garage, on the southwest corner of our lot. That was built sometime in the 50s. It's leaning in about each and every way, and is in serious need of repair. What we're proposing is to use the existing footprint plus an additional 9 feet on the north, towards the north side of the lot. So on the south side, the footprint would remain exactly the same, and on the west side of the property, the building or the garage would extend an additional, I think it's 9 feet, whatever that is in meters. It's the design is intended to match the existing home on the property. We're using existing shingles, existing brick, the same matching brick. It's going to be, and as well as the foundation rises above, sort of above the same way that it does on the home, extends above the ground about 24 inches.
Okay.
It is pretty much a mirror image of 90 Ruskin Street, which is the dwelling immediately across the street. So they have the same, pretty much the same double garage, except that in their case, it's not the second door is not recessed. In this case, the additional door or additional garage width is not quite as deep as the existing one.
Okay. No. From what I understand, the current garage is located 0.43 meters from 1 yard, setback 4.3 meters on one side, 0.48 on the other, and that's the existing condition, correct?
Correct.
Okay. And I think the committee's question to you is, why can't you comply with the bylaw? This is new construction. Why not 0.6 as the requirement in the bylaw states?
Well, there's not a physical reason why we can't. The reason why is we're trying to maintain an area between the home and the garage that's suitable for a deck, which is an existing deck that's there, and a side walkway. This is the reason why. Now, of course, by the other reason is that this additional space that at the back of the garage or on either side of the, they're just essentially more accumulative of leaves and dirt and stuff like that. There's not a lot of benefit to having. We didn't see any benefit to that.
However, that 0.6 is a very narrow strip of land if you're doing maintenance on a structure like this garage, and that's the reason why the setback is in the zoning bylaw.
Well, I mean, in the matter of a brick there would be quite a few years before that actually does occur, we'd hope.
This is going to be a brick, this will be a brick structure?
Yes.
Okay, ground, grade to the roof, all the way
Well,
up?
from grade up about on the south side, about 36 inches. It's foundation up about 36 inches, because if you look at the grade slopes from south to north.
Mhm.
So on the south side, the foundation is a little higher. It's about 30 or 36 inches. I don't remember.
Yep.
And on the north side, it's 24 inches. The neighbors on the south side's property drains onto this property. So for that reason, and in the existing condition, what happens is in the spring of the year, my garage is flooded because the property drains into from his driveway on the south side into my driveway, into my garage. It's clapboard right to grade, the existing garage.
And the new one's going to be brick most of the way to the soffit.
Oh yes, right to the soffit.
Okay.
And it's I have met with all the immediate neighbors.
Yeah. You understand that Mr. Kehoe and Ms. Cote have some concerns, and they're your neighbors to the west at 94.
Yes.
Have you spoken to them?
Yes, I did. We did speak with them, and I shared our plans with them. They objected to, and I did read their complaint. I'd like to sort of suggest that I suggested to them that I felt it was a minor variance, and I encouraged that, and I hope that the committee would agree to this, and therefore I suggested that it would be best if they incorporated their concerns and allowed us to mitigate those through their input as to what they wanted in design, how this impacted on them. They did write me back, and they advised me that they would be agreeable to me rebuilding the garage exactly as it is. Of course, I don't need that wouldn't require a variance. But that's what
well, the design of the current design of what you wish to put on there doesn't require a variance either, because you meet the bylaw requirements, correct?
Sorry?
So you meet your design of your accessory structure meets the bylaw requirements, right?
I'm not following you there.
The only variance we have is for the setbacks.
Yes.
It means that the structure that you're proposing doesn't need a variance. It meets the bylaw requirements for accessory buildings.
It does. It does. However, yes, it does.
And I'm assuming that garage is not going to be used for residential purposes.
For residential purposes? No, it's going to be used as a garage.
Mm-hmm. It's just going to be simply used as a garage. Okay.
Yes.
All right. Any other members have a question or comment regarding this application? I think, quite frankly, I think the committee would prefer if you built and met the bylaw requirements. However, I think you've given me adequate explanation for why you're seeking relief, and I think we need to take a vote on this. Ms. Oak-Sharon, in favor or opposed?
Excuse me, Mr. Chair?
Oh, yes, we have
a speaker.
Is the speaker still to be heard?
Mr. Kehoe is online.
Oh, I don't have him on my list. All right, Mr. Kehoe, please proceed. Is he there? Mr. Kehoe? We can't hear you, sir. Still can't hear you, sir. You're muted. We still can't hear you, sir. You're still muted.
Mr. Chair, perhaps Mr. Kehoe could phone in. He should have received the phone numbers to access a meeting through the telephone.
Yep. If you could phone in, Mr. Kehoe, that'd be appreciated. There we go. Is he connected yet, Madam Coordinator?
I don't see him as being connected.
Okay. Still can't hear you, Mr. Kehoe. Ms. McLean, you have a question, comment?
Just wondered, a question for the applicant. How much further would your proposed garage extend beyond the garage at 94 Ruskin?
So the current, the 94 Ruskin, currently his garage extends to approximately 2.1 meters past mine.
Okay.
And the new proposed addition would mean that my garage would extend 0.7 meters past his. So it would be 0.7 meters past his garage.
And how far approximately is his garage off the property line?
His garage is approximately about the same as mine. Currently, our garages are roughly about existing the same from the property line.
Hello?
Speaking, Mr. Kehoe.
Yes, I'm calling in by phone. Can you hear me now?
Could I have your address? Could I have your address, please?
Yes, it's 94 Ruskin Street.
Okay. So we have, I believe we have correspondence from you on this application. And we have been speaking with the applicant, and you have the committee in front of before you. So if you have concerns or comments, please make them.
Okay, thank you. The main concern I had was in reading the Mr. Nadeau's report. The assumption one might make from reading that is that the effect is going to be negligible on the basis that I think Mr. Goulet was just saying, the back of his garage won't extend much beyond the front of our garage. It looks, in reading that report, like it's basically two structures just with the same endpoint, in which case I would have to agree the effect would be negligible. However, our garage isn't shown on the plan, and so I don't think Mr. Nadeau was able to see that the proposed garage probably comes about 4 feet past the front of our garage, so going to the north.
Wrong.
Now, if that were the only problem, I mean, a 4-foot change in our view, I would agree that that wouldn't be that would be negligible. However, we are looking from our back door, we are facing southeast.
Mm-hmm.
We don't see the back of Mr. Goulet's garage at all. We see the side, the north side of his garage. So anything blocking our view, blocking air, blocking sun, is the side of that, the north side of that garage. And so by moving the entire, extending the width to the north by the 9 feet or 2.7 meters, whatever it comes out to, is taking a full 2.7 meters away from our sun, our air, and our view. In addition, the structure is also 3 feet higher, a full meter higher. So there is a significant change in our access to sun and air from that southeast facing. And my understanding was that if a structure were going to be built above the 4 meter requirement, there'd be an additional setback rather than reducing the setback. Also, Mr. Goulet has pointed out that he probably won't need access to the back of his garage because it's made of brick. We do have a wood fence running along that side of the house of our property. And this will make it more difficult to access that for repairs and maintenance.
You have a wood fence along your common property line from north to south?
Well, it's actually on our side of the property line, running from north to south, that's right.
And how far onto your property line is it?
It's right on the property line. It's inside the property line.
And how tall, is this a solid wood fence? Board on
Yes,
board?
it is. Yes.
How tall is it?
I think it's about 6 feet. Mr. Goulet could confirm the height.
And you maintain both sides of this fence, I take it?
Yes, we have to maintain both sides.
So, and your argument is that with a 0.443 meter wall in place, you're not going to be able to maintain it.
I think it would make it very difficult to maintain it.
But that's what's there right now.
It's there for part of the garage. It would be there for the balance of the garage as well, the extra 9 feet.
All right, but it's already there for.
Yes, that's right. There's already part of the fence that's difficult to maintain.
Okay.
My primary concern, though, is that it would appear from reading the report that there's no real change in view or air or sunlight because
the
garage is just a B.
Just to stop you right there, in the province of Ontario, there is no right to a view. We don't have that, unfortunately.
No, I'm talking about sun and air.
Can't talk about view. And as far as sun is concerned, planning staff, this accessory structure meets the bylaw requirement for height.
Yes.
So how high will this new garage be?
Measured from the midpoint of the roof, it would be 3.485 meters, correctly measures. That's relative to 3.6 meter maximum.
Okay, and that roof slope is the ridge line is east-west on the garage?
Firm on the plans.
On the ridge.
Yes, the ridge line runs east-west.
So,
But the roof is 15 feet high at the top, is it not?
yeah, the roof peak is, follows the southern property line of Mr. Goubet's property. So that reduces the, quite frankly, the visual impact on you because the roof peak is going that direction. Anyway, so
As I said, we have a
not happy with
southwest.
you're not happy with the height of the building. However, the height of the building is legal as far as the city of Ottawa is concerned, and there's no requirement for a variance for a building, an accessory building to be built this high on Mr. Goubet's property. And as you know, what we have before us are two variances, one from 0.6, which is the bylaw requirement, to 0.43, which is existing, and the other from 0.6 to 0.48, which is existing. So please continue.
Am I wrong in assuming that if you go above the 4-meter height requirement, you also require an additional setback?
Mr. Neto?
I'm not sure on which 4-meter height requirement is being referred to here.
Oh, sorry, 3. My understanding was that anything above 12 feet would require an additional setback. It might apply to only garages, I don't know, but I'm not an expert on this. It was my reading of the bylaw.
Mr. Neto?
I can only confirm that the proposed structure is compliant with the requirements for accessory structures. It's important to note that with a peaked roof like this, you measure the height from the midpoint of that roof between the eave and the ridge. And in this case, the proposed height of 3.485 meters is compliant.
So and that doesn't kick, so no other additional performance standards don't apply.
That would be correct.
Okay, so we're at a 0.6 meter setback requirement from the property lines. Yeah, okay. Please continue.
Well, I've made my objection known. It is very much affecting light, and it's affecting air.
Okay.
Unlike as presented in the report, it's not just a mere coming to the end of our garage.
Yeah.
It's the entire north wall is moving like the full 9 feet forward and blocking us.
Yeah.
So
that's understood. Okay. All right. Thank you very much. Mr. Wilder, you had a question or comment?
I do. He mentions the short distance that the current garage wall where it's located right now affects this fence. Now we're talking how much longer is this fence going to be again? Can you just reiterate that along that fence?
So currently the fence extends behind the garage approximately about 24 feet, 24 inches, about 2 feet, and along about maybe and about 6 feet along his garage. The fence is on the property line. I'd like to make that correction there. If you look at the survey shows the fence on the survey that was supplied with the application. So there would be an additional.
Is it true that he maintains the fence though, not yourself?
Well,
his fence.
There was a fence there that he removed and replaced. The fence is on
at
the
his expense, so it's his fence.
And I ultimately, I guess if we had to apply a responsibility, possibly it would be his fence, yes. Now, nothing has been done to the fence. I was put up, I don't know, 6 or 7 years ago. Thus far, nothing has been, no maintenance has been needed. There's a small section of the fence at the north side that I extended approximately 4 feet. So I extended the same fence an additional 4 feet on the north side.
All right.
All right. So again, let me understand this. So how you're extending out the garage from its current location and length along the fence. What distance again? Just exactly.
9 feet.
Nine extra feet. I
Yes.
see. Thank you.
Any other comments from the or questions from the committee? We've heard from the neighbor who has concerns regarding this. Heard from the planner. Perhaps we should reserve and further discuss this briefly after the hearing. Agreement? All right. What we're going to do, Mr. Goulet, is we are going to reserve on our decision, and you will get our decision within 10 days of today. Thank you very much for your input.
Thank you.
Thank you. Final application on the agenda today is item number 10. 529, 527 Broadhead Avenue. Consent to subdivide the property into 2 separate parcels of land in order to establish separate ownerships for the proposed semi-detached dwelling. It is proposed to demolish the existing dwelling and detached garage and retain the 2 detached sheds located at the rear of the property. Is the owner here?
Yes, Mr. Chair, that's me.
I have to administer the oath regarding the sign posting. Do you solemnly swear or affirm that the notice provided to you as part of the application process and by the committee was posted at the property to which the application applies for the prescribed number of days before the hearing and clearly visible and legible during the entirety of that time?
Yes, I do.
Okay. So you're back. All right.
You remember us.
Yeah, Ms. Smith. All right. Okay. So I guess we're well aware of what happened the last time. If you would like to give us a presentation on this, we will continue.
Okay, great. So thank you, Mr. Chair and committee members. This property is in a great location, in a small street running north-south between Iona and Clare Street, and pretty much between Kirkwood and Churchill Avenue. It's ideal for a family to live in. Next slide. And so that's why they want to sell this half of the semi-detached. To the south of the property, there's a path, and a recreational path, and it's close to Carling and Richmond Road as well. So it's really good for a family to live. We're applying for the consent to sever this property, and we're not asking for any minor variances. Next slide, please. The existing survey plan shows that the property is slightly irregular. The lot width is 12.71 meters and has a lot depth of 51 meters on the north and 51.13 on the south. There's 2 sheds at the rear of the property. The existing 2-story dwelling was demolished, and we have a permit to build the semi, and construction is underway. Next, please. So the new property, we're proposing to divide it into 2 sides, each having 6.355 meters frontage. The property owners themselves will live on the south side at 529 Broadhead. And they want to keep the existing sheds where they are, so that's why they're proposing an L-shaped property on their side. Next, please. The property is in Area B of Schedule 1, General Urban Area, and the zoning is R3R, which requires the following items, the setbacks, etc., that we are meeting. The next, please. The proposal meets the intentions of the official plan, sections 362 and 411, and it's compatible with the surrounding land uses. Just to the south, there's an existing semi-detached building that has been there since the 50s at least, from Geo Ottawa, and it is a 2.5-story building, just similar, about the same height as what we're proposing. Ours is a little higher, and so that's, and there is other development going around in that area, and a few other semi-detached, which we'll show in the next few slides. Next, please. So this is the existing street view, and that's the existing semi I was mentioning at 531, and now the building in between is gone. And so that's the 531 could be severed at any time as well. Next, please. This is further down the street, another semi. And this property has been severed. It's been severed irregularly, like we are proposing. And this zoning is actually in an R2 zone across the street. The next, please. The properties at the corner of Iona and Brawhead have narrow properties as well, and one of them is actually narrower than ours. It's 6.03, I believe, with 6.06, sorry, and the lot depths are less than ours, even though it's the same zone. So I guess they didn't meet the area's requirements. So next, please. You can see the views of those semis around the corner. So they're similar to what we're proposing, with stairs going up, a garage, stairs like to the upper level, and they're brick and some siding similar to what we are proposing. There was some question from a neighbor about the demolition sign when we first applied. I believe there was some concern that we were going ahead without proper approvals, but we did get a building permit, and this severance could happen at any time. You know, it could happen in 10 years. It could have happened before we started the design of the property. So there's no zoning requirement to apply for a severance before you start the design of the building or before you get the building permit. Next, please. That's the permits and demolition permit that were posted on their site.
Okay.
So yeah, we think it meets the intentions of the official plan and is desirable for the appropriate development of the property. I'd just like to note that some of the properties to the south don't meet the zoning bylaw either in terms of area. I'll just leave it at that. If you have any questions. Oh, well, we can go to the last one, is the elevation. The proposed elevation. I just want to mention that the rooftop patio is quite far set back. It's about 11.73 meters back to that first where the first windows are, and then it jogs even further back by another 3 meters to the back part. So that getting access to the rooftop patio is set back quite a bit. Thank you, Mr. Chair and committee members.
All right, Ms. Smith. Mr. Wilder, you had some questions?
Ms. Smith, just for your information, and I know this was a concern to some of the neighbors that they didn't see the permits. Contrary to the photo you showed, when I went by on the weekend, in fact, the 2 permits were down on the ground, posted to a little piece of wood in front of the porta potty. Let's just say it's there, but certainly not in the most, certainly not in a more visible place where you showed it up on the fence. So neighbors looking for it just perhaps on the weekend, or I don't know how many days before. It's not necessarily, I would say, hidden, but certainly on the ground in front of a porta potty in the far corner of the property. I mean, I saw it. I realized that the permits were issued on June the 5th, both for demolition and for the construction. And this was done afterwards. That's fine. But just wanted to clarify that your photo is incorrect. At least it's not where it was on the weekend.
Okay.
So
Yeah.
just to answer that, that photo was taken for the previous presentation. I'm sorry, Susan, I didn't send you an updated photo. But you're right, it is posted on that piece of plywood right now because we take down that fence quite a bit as we are accessing the site with trucks due to the width of the lot. So we post that in a place that is always going to stay, and since we're not moving the porta potty on a daily basis, we found that that's the best spot to keep it visible without removing it with the fence. If the committee prefers, or if there is a requirement, we can post it on the fence, but the fence does come down quite often when we are offloading material to the site.
Those notices are supposed to be visible to everybody.
Correct.
So you may want to move. Ms. McLean, you had some questions regarding the irregular severance line. And I think we discussed this the last time, or began to discuss it the last time before we adjourned.
I have some concerns about the irregular proposed severance line. I wonder, Ms. Smith, if you have any photos of those rear sheds?
I don't have any with me. Hazim, do you have any picture photos?
No, I don't believe I do. I'm sorry, not at this moment, at least. They are existing sheds. They have been there for since I bought the property a year ago almost, and I believe they've been there for a few years before that as well, speaking to the neighbors. One of the sheds does lie on the proposed, if we were to go straight, it would lie on that severance line as well. So another reason why we decided to do the L shape. And they are a good asset to have. And since we were able to meet all the zoning and bylaws requirements, we extended the backyard of the proposed sever lot to make sure that it does meet all the zoning and requirements needed in order to basically sever it.
Is the city okay with this severance line, the way it's been described on the schematic?
Through you, Mr. Chair, yes, the department has no concerns with the proposed severance line.
Okay. All right.
Just another question, Mr. Chair. Is there any reason that why those sheds can't be moved so that there's more of a regular severance line? I just note the properties on Iona, which you showed all go straight from front to back. And so that's my concern is one of the matters we have to consider is orderly development of land. And I question the rationale for jogging a severance line for two sheds. So again, is there any reason why the sheds can't be moved to one of the properties?
They are sitting on a foundation, and they are a structural shed. They're not portable sheds, so they are like framed with a roof on. So to move them means we will destroy them and have to rebuild them. So that's really the main reason I believe we can't move them, structurally speaking.
Okay, thank you.
Okay.
They did, by the way, I did show a slide at 544 and 546 Broadhead where they did a similar thing. My previous slide.
Yeah, it's on the the notification map that were circulated. I can see the line. It comes down and it takes a jog to the north, and both sheds are on the other property.
Right, but there's another property on that street that does the same thing, further to the south, 544 and 546 Broadhead. It's the 8th slide in our presentation.
Yeah, I'm looking at that right now on the distribution map that we received.
The one, yeah, that's right.
Yeah, okay. Yeah. Okay. It's unusual, but it's done, correct?
Yes, it's not, maybe not perfect, but
Okay.
it's development.
And as long as these aren't a problem in the future when properties go up for sale. All right. I have one speaker on the list on this, one of the neighbors, Mr. Anthonison, if he's there. Please.
Hi, can you hear me?
Yes, I can.
Let me see if I can get my camera going here too.
Okay.
Hi. Thanks everyone for your time. First of all, I guess you've all been able to read my comments, my submitted comments.
Yes, it's in our file.
Pardon me?
It's in our file, yeah.
Yeah, okay. Hazim been able to read my comments? You have. All right, so Hazim, you know I don't actually have much trouble with your property. It's trouble more with the precedent that it might set, right? It's news to me that we're allowed to have 6-meter lots on my street. I don't think there are any that big, but that small rather. But I can also see from having been engaged in this process for the last hour and a bit that my objections probably don't really apply as far as this committee is concerned. Is that correct?
Your objections are always registered by the committee.
Right, but they wouldn't be grounds for me to deny Mr. Abdel Naim his desire to partition the lot, right?
Well, why don't you articulate your objections to the committee?
Well, they're quite clear in the letter. I think there's plenty of room for subdivision. I just don't see, having listened to this meeting beforehand and having seen what's going on at 189 and 191 Hitchie, this is the kind of thing that I really don't want proliferating up and down both sides of my streets. These sort of, it's not quite Toronto's halls of concrete, but the halls are shorter and the halls are, the whole neighborhood turns into a wall on the front of the street and with narrow egresses into separate yards. So while I see that Mr. Abdel Naim is doing a good job in his separating the plots, I worry about being able to have input after these precedents are set, as they have been around the corner, brought up by Susan. I think.
Quite frankly, I wouldn't call them precedents because the R3 zone allows lots this wide on your street.
Apparently, which I didn't know.
The problem is your zoning.
Yeah, I thought it was a larger frontage, but
the other side.
I'm sorry, you just left. You just cut out there for me, Mr. Bottomley.
The other side of your street is R2, which has a different performance standard for lot width. Your side of the street, it's 6 meters.
Well, I'm glad to have this explanation given to me. Thank you very much. Now, the other thing that I'm curious about, and maybe you can answer this question, is how the lot managed to be built, how the 2 houses managed to be built on that property before any neighborhood people like myself got a chance to inquire about it. You're allowed to do that on your property? It's a little different from just adapting your basement to be an extra suite. It's knocking a house down and putting 2 houses up, right?
There's no variance required.
No variance
required. You and I can do exactly the same thing if we wish to knock down our house and rebuild. You don't have to have it. There's no public process. You just
Okay.
you meet the requirements of the city, get a building permit, and away you go.
Okay, well then, I'm glad to have my objections noticed.
Yeah.
And good luck to you, Hazim. I will see more of you, I'm sure. I don't think there's anything more for me to say.
All right.
Thank
very much,
thank
sir.
you. Thank you, Mr. Antonius.
Yes, we'll see you later. I look
Well,
forward to being your neighbor.
I'm sure I'll see you quite often on the street
Yeah,
when we move
great.
in.
Great, take care.
All right. Are there, Madam Coordinator, are there any other speakers on our list?
There are two additional speakers, Margaret Cody and Christina Ryluski. Both of them are online.
All right. Ms. Cody, your comments, please.
I had the same concern about precedence.
And what's your address, please, Ms. Cody?
Oh, 548.
548, okay.
So like Mr. Antoniessen, across the street, I was not aware that there was a different zoning on one side of the street and on the other side of the street.
That's correct, yeah.
So on my side of the street, it's R2.
Yep.
And what is the minimum allowed for that, please?
For a semi?
Yes.
I don't know exactly what this R2 zone is. Perhaps one of the staff members, because it varies.
It's on our slide 5. The lot width is 6 meters.
Not
For R2?
Also for R2? Okay. Yeah, I'm not sure.
I'm in an R2F zone, and it's a 9 meters for each side of a semi in my zone.
Excellent. So that means that on my side of the street, we cannot make it any smaller. And on, unfortunately, Klaus's side of the street, it can be smaller.
Yeah, the legal lot width is 6 meters for a home on the street if you want to put up a semi.
And by the way, it's different for a single family home.
Yeah.
The widths are different for single family homes. R2D is for a semi, right? And what is it for a single family home? Single family home.
Yeah.
Okay, so you provided some clarity so that I can now understand that nothing else on my side of the street could be built to the standard that is being applied to 527, 529.
Unless there's a rezoning or a minor variance application for narrower lots. And if there's a rezoning application that goes through council and they approve it, it happens. And if it comes to us and the 4 tests of the act are met, the same thing can happen on your side of the street.
Okay, but hopefully right now there's no application to change the zoning on my side of the street.
We're not aware of any at the present time.
Good news. Thank you.
Okay. And we have one more speaker, I believe. Ms. Berluski.
Good afternoon. Good afternoon, Mr. Chair.
And your address, please?
525 Broadhead.
Okay, thank you.
So we're right next door to the new units.
Immediate units.
And just like our neighbors have said, Mr. Chair, we just wanted to express some concerns with respect to the potential precedent. And I just wanted to make a comment with respect to the signage. So I didn't notice the photograph that was shown, and I heard the comments with respect to why it was moved, but I just wanted to make a comment to indicate that that fence didn't go up until after the building was demolished. So I'm not sure whether or not there was, to my knowledge, there wasn't anything posted beforehand. I mean, I don't know if, I just wanted to state that for the record, I guess.
Well, it's a requirement that those get posted, by the way. So, and I think the applicant has made it's made very clear to the applicant by Building Code Services and the planning branch that those signs have to go up and be visible to the public.
All right, thank you.
But I you really shouldn't be calling this a precedent. Your zoning allows lots this wide.
Fair. Okay. All right.
And if you guys are concerned at all with R3 zoning and narrower lots, I would suggest that you raise the issue with your ward councillor. maybe you should have your part of the neighborhood rezoned to R2 from R3.
All right, okay. And if I may just ask a question, I know that obviously these types of comments are not relevant to the issue that the committee is deciding right now, but I'm just wondering if there were any problems in the future with respect to the dwelling. Is it just the city that we contact, or is there somebody specific that we get in touch with?
Problems in what manner?
For example, if there's drainage problems or problems with the windows or anything like that?
Well, if there's drainage problems, yes, you contact the city.
Could I address that, please?
Ms. Smith?
To get a building permit, we have to do a grading plan, and we have to have a civil engineer or an engineering person design the grading so that the water does not go onto your property, and the city checks it very carefully. So if there's a problem with water on your property, I'm not sure, like that we do everything we can to avoid that. And with respect to windows, there is a building code requirements, how close you can be to a property line with the number of windows. The closer you are, the fewer the windows. So there is a restriction on the number of the windows near a side yard property line.
Okay, thank you very much. That clears it up.
Okay. You may want to talk to Ms. Smith about that for further details after we're done here.
Mm-hmm. Perfect. Thank you.
Or Christina, you can touch base with me. Your mom has my number as well, so at any point you can touch base with me about it.
Mr. Wilder, you had a question or comment?
Yeah, I do. I mean, Mr. Abdul was very fortunate. You know, these young families do their research. They found the zoning that's R3. Basically, you know, I used to work for the city, and I know very well that we have anomalies like this here where it's R2 on one side. He'd have had a little more difficult time perhaps across the street in terms of variances if he found the exact same home he demolished across the street in the R2 zone, but he was fortunate enough it's an R3 zone. You know, I've raised this before. I would encourage those who are still on the line, who are neighbors and who live in the R3 zone. I don't see any reason why this and the block abutting it towards Leather Route, why that's R3, walking the area and walking across the street, while the other side is R2, to be very honest with you. R2 wouldn't be unreasonable. I would encourage you to speak to your counselor if you're concerned about, for starters, about the provisions of the R3 zone as it permits the semis opposed to the R2 zone, which, as Mr. Blatherick pointed out, as the chair pointed out, you could see variances still come forward from the R2 zone, but it really requires a change in zoning. We can't really do anything about this. It's something you really have to take up with your ward councillor. Now that you're aware of this, you might want to speak to him saying, why is it that one side of the street, why is the dividing line on the other side of the street between the R2 zone and the R3 zone? Just have that comment. So that's for the neighbors. Mr. Abdul, I'm just wondering, why is it necessary to have the two sheds? What is it so important that you cannot, you know, I really have a concern, notwithstanding there's been other examples, has been pointed out, where we do have this irregular shaped property line. What is it that was so necessary for you to have the two sheds? I realize you're living in one half. I understand that's not just a case that, you know, you're not flipping this, that you're living in one half, you're going to sell the other half. It'll make for a shorter backyard for the other half that you're selling naturally, when you're going to have the, you know, two sheds effectively on your property line. What is the need?
The sheds are in relatively, when I bought the house, the sheds are in relatively new condition. They're structural, they're built, they're sound, and they provide good storage in general. We reviewed the zoning and we reviewed the requirements to meet the minimum setback, and we made sure that it meets all the zoning requirements, the minimum setback. And for a lot that is this narrow and long, the backyard is actually much larger than typical backyards in the neighborhood, even for the lot that we're selling. I believe the lot that we're selling or eventually will sell is the depth of it is about 140 something feet, which is pretty deep for lots in Westboro. Susan, I don't have the drawings in front of me, so feel free to correct me.
What is it?
So we didn't see a reason to demolish a nice existing shed that is structurally sound. And eliminate the opportunity for storage on the property.
Miss,
Yeah, the depth is 45.7 meters deep of the whole property now. Where's it to you?
I guess
Yeah, no, that's the new one. That's the severed one. Sorry, I got a tickle. Yeah, the whole depth.
What if the half that you're selling, what if that new owner wishes to have a shed for storage as opposed to using the garage? So there'll be a third shed built then, is that right? If he decides, since the other shed is yours, the two sheds, they need a shed. So they will go ahead and then build a third shed on their property, is that right?
I cannot speak on their behalf, but that will be up to them.
Jeez, that's ridiculous. All right.
Sorry, sir. I wish I can answer.
Ms. Oak Sharon, you had a question or comment? You're muted.
Thank you, Mr. Chair. I was wondering if the applicant would be amenable to having a straight property line. As it stands, I don't feel that I can support it because I don't think it's orderly development. So I'm just wondering how they would feel about that.
I'm not. I honestly not sure. We currently own the property, and we feel like we with the severed land, we're going to provide ample, more than regular backyard for the new owner to enjoy their backyard and green space. We made sure that we follow all the rules and bylaws when we were designing. I know Susan spent quite a bit of time making sure that we meet all the minimum setbacks and depth, and we did a last minute change even to make sure that it meets it by 0.1 of an inch. That was an error in the calculations that we discovered at the end. We're looking forward, my wife and I, to enjoying that extra storage, to be honest. My wife was here, she would comment on how much stuff she has to store. And that's really the only reason why we're looking forward to that extra storage space that we currently own.
Okay, to follow up on Member Wilder's question, you couldn't consider selling that shed as part of the property on the other side in order to obtain a straight severance line?
We prefer not to, given that, like I said, the lot that we are proposing to sell eventually down the line exceeds most lot sizes in the neighborhood. So we feel like there's most lot sizes of severed lots in the neighborhood for townhouses. So we feel like we're not taking away anything from the future owners who would obviously buy the lot knowing the size and the development that is on it.
Okay, thank you.
Right. Ms. Smith, you're aware of the conditions that have been articulated by the planning department. Cash in lieu of parkland, confirmed in writing the existing dwelling is removed, services capped, existing water services blanked, all that stuff, independent services for both severed and retained. A joint use and maintenance agreement is required. Confirmation in writing that the accessory structure has been demolished in accordance with the demolition permit, and then a grading and drainage plan has been submitted before building permit stage. Also, I think confirmation of fire separation of the party wall. You're aware of those?
Yes,
Yeah,
thank
okay.
you. Yeah.
Right. I'm Ms. Oakshara dissents on this application, I'm assuming, because of the severance line.
I do.
I'm prepared to accept the application as proposed. Mr. Wilder? I can't hear you. You're muted.
I'm really torn on this, to be very honest with you. I mean, I like neat backyards, and I suspect if I was buying this, I'd have a shed put up as well, which is not going to make for a very attractive situation in the two rear yards. I guess this has been done in other situations, which I'm not aware of in terms of what type of sheds were in those situations. All right, I'll in this instance, I'll support the application reluctantly, very reluctantly.
Thank you, Mr. Wilder. Ms. McLean?
I won't be supporting the application, Mr. Chair. I don't feel that it's orderly development of land, and I don't feel that two sheds should dictate a lot line in perpetuity.
All right, thank you. All right, well, that's a 2-2 vote, which means the application has failed and has been dismissed.
Can I ask Hazim for another consideration?
Yes, of course.
What if you put the property line between the two sheds so it makes a very small shed? Sorry, a very small jog, and then you have each side gets one shed, and there's a jog of maybe 1 meter. I'm just wondering if the committee would support that, if you would accept it.
I would prefer, obviously, if we keep the property as is, but if the committee believes that that's a better proposal, I'm okay with accepting that.
Which means we'd have to have amended documents filed with us.
That's right. We'd have to get the draft plan changed.
And how quickly can that be done?
We
I
can
think that, yeah.
probably do it within 4 to 5 business days. I was able to get this one amended in 2 days.
And the line would go between the two sheds, equidistant?
That's what I'm thinking, yes. So it's a small jog.
Ms. McLean?
I think we voted on this already, Mr. Chair. I'm not so sure now that we can go back on our vote. And then secondly, I'm not so sure again on the same principle that I don't think sheds should dictate a property line in perpetuity.
Yeah. I think we'll stay with our decision. And the decision is that 2 of us are reluctantly supporting this application and 2 of us have not. So
what are my options right now in terms of the severance?
You're going to have
Sorry, this is my first time doing this.
Well, this application has been dismissed, so maybe it's time to sit down with Ms. Smith, and you may have to be
resubmit an application.
Resubmit another.
Or apply to something higher.
Okay.
This item on the agenda.
Okay, thank you very much, committee members.
You're welcome.
Thank you.
So we're getting an email for the after meeting.
Yes, Mr. Yes, Mr.
Okay.
Chair, I have sent it.